Good morning, everyone. My name is Terrance Carter, and I'm going to be involved as a presenter in the Fasken Carter Healthcare Philanthropy seminar that we're doing today. We're delighted to have you participate with us. And I just want to give a little bit of the background. We've been doing these seminars for 17 years. We started in 2004. And it's been a joint initiative by Fasken's and our firm, Carter's Professional Corporation. We've had a wonderful relationship in putting these programs on for the healthcare philanthropy community. When we started off, we were at Sunnybrook Hospital at a beautiful facility located there, and then moved downtown Toronto in the last number of years. Obviously, we're not there today, but we're with you, hopefully in a way that will be relevant for you and easy to access. So we're delighted to have you participate. We have 154 registered, which is a record for us. So having the virtual connection, I think, is helping in that way. When we look for topics each year, we're wanting to be relevant. Well, it was pretty easy to come up with a topic theme for the session today, and we're focused on healthcare philanthropy in a COVID-19 world. We're all dealing with the reality of what that involves. So what we have for you today is sort of a walkthrough, hold your hand guide to some of the key issues that we as practitioners at our two firms have chosen for you. And we have wonderful speakers that are going to be presenting on different topics. Jackie Demczur will be dealing with charity law in the pandemic. Corina Weigl will be dealing with the impact of COVID-19 on donor agreements. I'll be dealing with due diligence and crisis management during a pandemic. And then Laurie Turner will be dealing with advancing your health mission during COVID-19. We have lots of resource materials available for you, both with the presentations, but also at our two law firm websites at faskens.com and carters.ca. Lots of materials dealing with COVID-19 and charity and not-for-profit law materials. So just encourage you to go to those. So now I'm going to turn it over to our moderator for the day. Lynne Golding is the leader of the Fasken's Health Group, and delighted to be able to work with Lynne. We've known each other for many decades now, and so I'm delighted to be able to do this presentation with her. Thank you, Lynne, and over to you.
Thank you very much, Terry. It's a pleasure to be here with you as well. The Carter's Law Firm and Fasken have had a bit of an affiliation for well over 10 years now when it comes to serving each other's charities clients, and I think it's been a relationship which has been great for our firm and even better for our clients. So it's really a pleasure to be part of this presentation with you today. So as Terry said, my name is Lynne Golding. I'm a corporate lawyer at Fasken's. I'm the head of our National Health Law Practice Group. We are a group of about 30 lawyers. We practice all different types of law. I'm a corporate lawyer myself, but what we have in common is our client base. So everyone in our group devotes a large part, if not all, of their practice to serving clients who are healthcare providers, healthcare regulators, or healthcare funders. And you can imagine that most of those clients are charities and not-for-profit entities. So this is a session that we always look forward to every year, dealing with clients who cross both of those industry groups. Before we begin, there are a few housekeeping matters that I'd like to go over with you. If we were at the office, I might tell you where the fire exits were. I don't need to tell you that. You'll all know that within your own house. I have more mundane things to tell you about today. The first is materials. So you will see a button at the bottom of your page, I believe. And if you click that, then you will be able to see the materials that we have available for you for download. Questions, please send your questions. There's a box that for the chat box, please enter your questions there. At the end of each speaker's presentation, they will open that chat box and answer the questions that they're able to within the time available. In terms of tech support, you'll also see a button for tech support. So if you have any issues that way, please just go onto that box and we'll get help for you right away. Finally, we will have a survey at the end of the webinar. We'd love it if you take the time to fill that in. It really helps us to know whether you are getting enough out of these seminars we're offering, and also if you have any suggestions for future topics or approaches, please do let us know in that survey.
Good morning, everyone. My name's Jackie Demczur. I'm a partner at Carter's Professional Corporation, and I'm happy to be with you this morning to give you the 2020 update, charity law and the pandemic. If you move to the first slide, you'll see an overview of what I'd like to talk about today. And the first thing I'd like to point out is that the information in our webinar, or my presentation today, is current as of Wednesday, June 17th. But given the constant evolving situation with the pandemic, it's important that you regularly review and update the pandemic-related requirements and programs that we're going to talk about in this presentation and throughout the entire webinar. So you'll see what I'd like to talk about today. I'll have some introductory comments to sort of set the context for Canadian charities in this new COVID world. I'll give you a bit of an overview of the federal and Ontario relief programs that are currently in place. I'll dive a little bit deeper in a corporate update, both at the federal and the Ontario level for not-for-profit corporations, and this impacts those who are registered charities as well. And then an update from the Charities Director at Canada Revenue Agency. So if we move to the next slide, we'll talk about some introductory comments. And so everyone is certainly aware of the significant events that have taken over the last 3 months. But it's good to set the overall context for the webinar today. On March 11th of 2020, as we all know, the World Health Organization declared the COVID-19 outbreak as a worldwide pandemic. And since then, the Canadian government has implemented a number of programs in response to the pandemic. Here in Ontario, the government has declared a province-wide declaration of emergency on March 17th of this year. And that declaration of emergency has been extended several times and is currently in effect until June 30th, 2020, at the end of this month. Further extensions are possible, and in that regard, this past Wednesday, the provincial government tabled a motion to extend the declaration until July 15th, and there's a vote expected on that motion next week. As of last Friday, June 12th, certain regions in Ontario entered phase 2 of the reopening, and effective today, 7 more regions here in Ontario entered stage 2 as well. At the moment, only Toronto, Peel, and the Windsor area remain in stage 1. So I'm going to move in the next slide to an overview of the federal relief programs that are currently in place. Starting first with wage programs, the first one to bring to your attention is the Canada Emergency Relief Subsidy. And this is a program whose goals are to prevent further job losses and encourage employers to retain their employees or to rehire them if they've been laid off due to the pandemic. This program was enacted in April 11th of 2020, but on May 15th, it was extended to the end of August of this year. The purpose of the program is to provide a 75% wage subsidy to eligible employers, and these include charities that see a drop of at least 15% in qualifying revenues in March 2020 and 30% in subsequent months. You'll see that there's some limits per employee what you can get for a subsidy, but there's no overall limit on the subsidy amount that may be claimed by the employer. If we move to the next slide, and this was a question that came in prior to the webinar, there have been some issues with the CEWS program in relation to some charities being found to be ineligible where another entity is administering their payroll through their own business number with CRA. And to address this, the federal government introduced Bill C-17. It had first reading on June 10th, and it proposed to correct and expand who qualifies as eligible entities for the CEWS program. And this will include entities who use another payroll service provider to administer their payroll. Once this bill is enacted, and this particular change will come into effect retroactively to April 11th of 2020, and that's the same date that the program itself came into effect. Moving to the next slide, I'd like to talk to you about another program called the Temporary Wage Subsidy. This came into effect on March 25th of this year, And it entitles employers to a 10% subsidy, which is equal to the 10% of remuneration that they paid from the period March 18th to June 19th today, up to a maximum amount per employee and a maximum amount per employer. The two programs, the CEWS program and this program, spell off against each other. So if you're entitled to the temporary wage subsidy, then that amount would be deducted from what you would be entitled to under the CEWS program if you qualify. Moving now to the next slide, business programs. There's two to bring to your attention. The first is the Canada Emergency Business Account. And this is a $25 billion program that provides interest-free loans up to $40,000 to small businesses, charities, and not-for-profits to help cover their operating costs during this period when revenues have been reduced. This is a loan that you apply for through your bank or your credit union. Initially, you had to have a payroll between $20,000 to $1.5 million in 2019 to qualify. But in May, they expanded the list of organizations who could qualify for this program, those with payrolls under $20,000, as long as they meet additional criteria. This is a loan. You're expected to pay it back, but if you are able to pay it back before December 31st of 2022, then you'll be entitled to up to 25% loan forgiveness, so $10,000 of the $40,000 loan. Moving to the next slide, the next program to bring to your attention is the Canada Emergency Commercial Rent Assistance Program. This is offered through the Canada Mortgage Housing Corporation, and it's intended to lower rent by 75% for impacted small businesses, charities, and not-for-profits who rent their property from what are called qualifying commercial landlords. This doesn't apply to any government-owned properties or where the government is a landlord, though you'll see on the slide there's some exceptions to that. This application process opened at the end of May, and it will be open until the end of August if your organization is eligible for it. Later in the presentation, Laurie Turner will be speaking more broadly to the premises issues affecting charities as a result of the pandemic. Moving to the next slide, I'd like to just highlight some support funds for the sector that the federal government has put in place. The first is the Emergency Community Support Fund, and this provides funding to qualified donees, which includes charities and not-for-profits serving vulnerable Canadians delivering essential services. The application process has been open for this support fund since May 19th, and you'll see at the bottom of this slide and onto the next slide some of the criteria that you have to meet in order to be eligible for funding from this particular fund. As well, there's other targeted measures that the federal government has put into place. There's a fund in place for support for rural businesses and communities. And then moving to the next slide, you'll see three other funds that the federal government has put in place. An emergency support fund for cultural, heritage, and sports organizations affected by the pandemic financially. A local food infrastructure fund that's focused on improving access to food for people and addressing food insecurity issues as a result of the pandemic. As well as a regional relief and recovery fund, which is available to small businesses as well as charities and not-for-profits in certain parts of the country to help mitigate the financial pressures exerted on them as a result of the pandemic. I'd like to turn now to Ontario relief programs, where they're focused predominantly on providing support funding for different organizations as a result of the pandemic. And in the Ontario Action Plan responding to COVID-19, the government has made some significant financial contributions in a number of areas. You'll see $935 million has been set aside for the hospital sector, both to expand capacity and get COVID assessment centers up and funded. $160 million to public health in relation to COVID, $243 million to support the long-term care sector. Moving to the next slide, there's $75 million committed to PPE and obtaining critical medical supplies for frontline staff, as well as $1 billion COVID-19 contingency fund. As well, the Ontario government has committed to municipal social services funding, and this is to provide money to charity and not-for-profit social services organizations to improve their COVID response based on local needs. As well, some new employment measures have been put in place, specifically an infectious disease emergency leave is now available, and it provides temporary relief from the Employment Standards Act. And Laurie Turner will be speaking to that topic a bit more later in her presentation. So I'd like to move now to a corporate update and dive just a little bit deeper But to provide some context, there's both federal and here in Ontario provincial relief efforts to extend the deadlines to complete corporate filings. As a result of COVID, obviously, charities and not-for-profits have had to adjust how they hold both board and more significantly, their membership meetings. And this is for a number of reasons, including the fact that there are currently limits here in Ontario on the size of public gatherings that can take place. There's physical distancing requirements that have to be complied with. And directors of not-for-profit and not-for-profit corporations have to balance their fiduciary duties between making sure the corporation fulfills their legal requirements, as well as protects the health and safety of their directors, members, staff, and volunteers. So with all of that in mind, we'll look first at the federal level, the Canada Not-for-Profit Corporations Act. And this statute applies to all not-for-profit corporations that are established at the federal level. So if you're an Ontario corporation established under the Ontario Corporations Act, the next few slides won't apply to you, but I will get to Ontario corporate requirements shortly. So looking at the CNCA, we'll look at corporate filing deadlines first. All regular CNCA corporations have to file an annual corporate return each year, and this is normally due within 60 days of their anniversary date. It's the date that they're incorporated, amalgamated, or continued under the CNCA. And the corporate filing is relatively straightforward, but one of the pieces of information on that filing is the date that you held your last AGM. So if you can't hold your AGM because of the pandemic, then that delays filling out the ability to fill out your corporate return. So what Corporations Canada has done is for CNCA corporations who have an anniversary date between February 1st and July 31st, they've extended the time period from the 60 days to right over to September 30th, 2020. And that same extended deadline also applies to federal special act corporations. These are corporations established by an act passed by the federal parliament. So if we move now to board meetings first, under the CNCA, directors are permitted to attend board meetings by telephone, electronic, or other communication facilities if certain conditions are met. And you'll see them set out here on the slide that all the directors have to consent to the meeting being held in this way. The facility that you use to hold the meeting has to allow everyone to communicate adequately with one another. And you have to make sure that your bylaw doesn't preclude holding board meetings by telephone or electronic means. It's also important to remember that the common law does not permit proxy voting at board meetings or for you to appoint alternative directors. Right now, there's no relief from Corporations Canada on these CNCA requirements, but usually it's not a problem. Most bylaws do allow directors to hold telephone or electronic meetings, but you do need to check your particular bylaw to make sure that that's the case. So if we move to the next slide, we'll deal with how the CNCA requirements for members' meetings, specifically the annual general meeting that a corporation has to hold each year with its membership. So we'll look first at the forms of AGMs that could take place under the CNCA. So the first thing to know is that under the CNCA, there's a default rule that members are entitled to participate at AGMs in person. In addition, it may be possible under the CNCA and in your corporation to hold what's called a hybrid meeting. This is a meeting that is a combination of people attending in person as well as participating by telephone or electronic means. However, you have to be aware that your bylaw may preclude hybrid meetings being held for an AGM. You have to check your bylaw carefully to see whether the corporation opted out of holding a meeting in this way or whether it's permissible. As well, it's possible under the CNCA to hold AGMs as a virtual meeting. This is a meeting that's entirely held by members participating by telephone or electronic means. No one attends in person. But corporations are only permitted under the CNCA to hold virtual meetings if their bylaw specifically authorizes them to do so. So the first step is you need to carefully check your bylaws to determine the form of AGM that your corporation is entitled to hold. If you don't have the ability to hold the type of meeting that you want to, there may be options to amend the bylaw under the CNCA, but you'll have to again check your bylaw carefully to determine if the board can do it on its own subject to ratification by the membership or whether the membership has to approve that change first before it becomes effective. So we'll move now to the next slide, which deals with how voting takes place at AGMs under the CNCA. So for both hybrid, the combination meeting, and virtual meetings, members are permitted to vote by telephone, electronic, or another facility if they meet certain requirements under the CNCA. And you'll see the two key ones here, that votes have to be gathered in a manner that permits their subsequent verification, and the tally vote has to be able to be presented to a corporation, to the corporations, in such a way that the individual members' votes remain anonymous. And we'll move to the next slide to deal with timing, because this is a significant issue given the pandemic. And under the CNCA, AGMs must be held initially once you are incorporated, 18 months after incorporation, and thereafter you have to hold your AGM at least 15 months or no later than 15 months after the previous year's AGM. In addition, the CNCA also requires that AGMs of corporations have to be held within 6 months of the financial year end. So if you have a December 31st year end, the CNCA requires you to hold your AGM by June 30th of the following year. And unfortunately, Corporations Canada hasn't been able to provide any blanket relief to CNCA corporations from this requirement. However, there's always been the ability, if you're not able to hold your AGM on time, to apply to Corporations Canada for an extension of the time to call your AGM, but you have to meet their policy requirements in order to get approval. Fortunately, although it took until May 12th of this year, there's now a streamlined online process that Corporations Canada has made available to get permission to delay your AGM due to COVID. And it's a very straightforward application process. I've had clients that have done it, and approval comes relatively quickly from Corporations Canada. So if we can go to the next slide and just finish out the federal corporate update. Bill C-17, which I mentioned earlier, was also, it will enact, once it's passed, the Time Limits and Other Periods Act, which provides relief for certain CNCA deadlines. And specifically, what it will do will allow the minister responsible for the CNCA to make orders to extend or suspend time limits imposed under the CNCA, and do so retroactively to March 13th. You'll see some of the types of orders that the minister might be able to make in relation to calling and providing notice of meetings, as well as circulating the annual financial statements to members and directors. However, until this bill is passed and orders are actually made by the minister, the CNCA timing restrictions that I just described to you will continue to apply. So I'd like to turn now to Ontario corporate law and give you an update on not-for-profit corporations under this statute. In terms of filing deadlines, an OCA corporation has to file its annual return at the same time as it files either its tax return, its T2, if it's a not-for-profit for tax purposes, or if it's a registered charity, it will file its T3010. So depending on what you are, you file your annual corporate return at the same time as your applicable tax return. Due to the pandemic, though, the province has indicated that the annual corporate returns can be, their filing date can be delayed and coordinate when they file their tax or information returns with CRA, and that deadline date has been extended, and I'll talk about that in a few minutes. If we look on the next slide to board meetings, under the OCA, directors have always been permitted, if their bylaw doesn't prohibit it, to hold their meetings by telephone or electronic means. There's also under the OCA the option of using written resolutions in lieu of holding a meeting, but the important thing to bear in mind here is that those written resolutions have to be signed by all the directors in order to be passed. To provide some relief, though, Bill 190 was passed by the provincial government on May 12th of 2020, and it amends the OCA by adding a new part, Roman numeral 8, on special rules during the emergency declaration. And as a result of this part, certain provisions under the OCA have been suspended and replacement provisions put in place. And one of the key ones to be aware of is that OCA corporations may now hold board and members meetings during the pandemic electronically. And this is the case even if your bylaw specifically prohibits electronic meetings. So there's no need, different than the CNCA, to have to amend your bylaws to have the ability to hold electronic meetings. The province has put legislation in place to allow you to do that during this emergency period. I'm going to move now to members meetings, specifically the AGMs that have to be held for OCA corporations. And similar to the CNCA, the OCA says that you have to hold your AGM 15 months after the last AGM. That's the outside date to hold your AGM. But different than the CNCA, the ONCA doesn't impose a time period after the end of your fiscal year end for you to hold that AGM. So the first thing you need to do in order to figure out when your AGM has to be held in 2020 is check back to see when your last AGM was held. Get that date. You add 15 months to that date, and that will determine the current or the OCA deadline date to hold your AGM. Then once you know what that date is, you can look at the relief provided by Bill 190 and set out in this slide to determine what period of time you have as an extension to hold your AGM this year. So if your AGM was required to be held during the emergency period, which right now goes to June 30th, but will be extended to July 15th, we anticipate, and perhaps longer, your AGM can be delayed and be held no later than 90 days after the day the emergency is terminated. If, though, you find out that your AGM is required to be held within 30 days after the emergency terminates, then your AGM can be delayed and be held no later than 120 days after the emergency ends. The last piece of information to provide you with a corporate update on, if we can move to the next slide, is Bill 190. And it also enacted a new statute called the Alternative Filing Methods for Business Act 2020, and it addresses some of the public health and safety concerns arising from the current emergency that we're in. And specifically, it permits documents that are required to be filed in person or by mail under certain statutes to be filed by alternative methods. It also allows electronic signatures and electronic copies of documents to be filed electronically as opposed to original hard copy. And you'll see under the OCA that some of the documents that can be filed by these alternative filing methods include applications, notices, declarations, and other accompanying documents. So finally, I'd like to just give you an update on what's happening with the Charities Directorate at Canada Revenue Agency. For registered charities, important thing to be aware of is that your annual charity information return, your T3010, the deadline date to submit that has been extended. And so what CRA has said is that if your return was due between March 18th of 2020 and December 31st of 2020, your deadline date has been extended to December 31st of this year. So it gives, if you have a December 31st year end, normally would have been due June 30th, and now you have another 6 months to get that return completed and filed with CRA. In relation to the operations of the Charities Directorate, the call center restarted its operations on April 28th. It had been shut down for several weeks as a result of the pandemic's declaration, but now it's up and running. In terms of audit activities, those audit activities by CRA remain suspended, but charities can continue to send in responses to CRA on any previous or ongoing audits, as well as any other questions they have regarding audit activities. And finally, in relation to review of pending applications for charitable status, on May 13th, CRA announced that it had resumed its review of both digital and paper-based applications for charitable registration. It's been engaged in a preliminary review of all those applications to identify applicants that are providing pandemic-related charitable programs in an effort to try to expedite their review. If you have an ongoing application with CRA and you had received an information request from CRA about that application or requesting more documents, CRA has indicated that they've extended the time period to respond to those requests until July 31st. And they've made clear that they won't close any applications without prior contact to the applicant. Finally, the CRA encourages all charities to keep up to date on what's happening at CRA and the Charities Directorate through the charity and giving web pages, as well as to utilize my business accounts to engage in digital services and communicating with CRA. So those are the conclusions of, that's the conclusion of my comments today. I have a question that's come in asking if there's any estimate as to the timing of Bill C-17. I'm sorry I don't personally know that timing. I know that they've moved quite quickly in getting a lot of this legislation through. I would anticipate that it would be relatively quickly they would have that completed, but I don't know the exact timing of, at the moment. Perhaps some of the other speakers might have some insights into that. So that concludes my presentation. I thank you for your attention, and I'll look forward to hearing the rest of the speakers today.
Well, thank you, Jackie. You know, here I was saying things to worry about as part of your housekeeping matters. I never thought to say, and make sure your internet connections are all working well. Somehow ours went down. My daughter was on a conference call for her work, and here I was in the middle of these introductions. I was going to say some great things about you, Jackie, but I'm sure Terry did a very good job on that. So thank you very much, Jackie. That was a lot to get through, and we really appreciate you taking us through all of those really important concessions that have been made available to both federal and provincial companies during this pandemic. So our next speaker is my partner, Corina Weigl. Corina is a co-leader of our private client service group. Now this group is practiced on estates and family businesses, and Corina is a leader in structuring these arrangements. She really works with clients to try and help them protect their property, both while they're living and how their property will be looked after after they have passed on. Now, a lot of what she has to do is to help their clients with gifts that her clients make to charities. And so her great expertise in the area of charities and not-for-profit considerations really makes her a very good asset to the clients as they plan their philanthropic goals. Corina was named the Lawyer of the Year for Trusts and Estates in 2017 by Best Lawyers of Canada. She frequently speaks and writes on these subjects. And I know that she'll provide us with some interesting remarks about the impact of COVID-19 on donor agreements. So Corina, over to you.
Thank you, Lynn, for that nice introduction. I take it that alarm that I heard during your introductory comments is what I might hear if I get too close to my 30-minute time allotment, so I'll bear that in mind. Good morning, everybody, and thank you for joining us in this new world we're all in. And as we enter week 14, since the COVID-related lockdown imposed in Ontario, I think it's safe to say that the pandemic has and will likely continue to affect all of us in profound ways. From the way we conduct our activities of our day-to-day lives, to the way we conduct our work, to the way we interact with family and friends. One thing is clear, there's no certainty. What was normal 3 months ago may never be normal again. Layered on top of all of that change that we're all individually experiencing are the larger societal implications of COVID, whether that be in the realization that our definition of frontline workers is now far broader than what we may have traditionally considered it to be, now encompassing those folks in the food and PPE supply chains, for example, to the realization that while viruses may be agnostic about their victims, there are definite socioeconomic factors that underlie where clusters of the virus appear, to the worry that the longer-term economic implications arising for the measures taken to flatten the curve that we're now beginning to have to grapple with. So what does that mean for all of you who are with us today in the context of the area of economic activity where healthcare and philanthropy collide? Well, it means a lot. Not only are some of you members of the frontline workers who've been in crisis mode for many weeks trying to deliver the services you do, but you're also often highly reliant on charitable dollars. And it goes without saying that both during this crisis and undoubtedly coming out of it, the need for funding for your organizations is going to remain prevalent, and it's undoubtedly going to increase. The challenge, though, for your organizations, particularly those that rely on charitable funding, in the context of what might be a darkening economic horizon, is that just when that need for financial support may be increasing, there's the specter that perhaps future donor funding is going to start to fall off, or perhaps donors are going to start to look at their agreements with you, perhaps they're going to start to look at their pledge agreements and question whether they can continue to satisfy any outstanding payments. So what does that mean for you folks? Well, besides the obvious need to try and access new dollars, you may want to step back to better understand the implications of accessing gifted funds that are already on your books and considering whether there are some risks with those outstanding pledge payments. In essence, it's a bit of a perfect storm. And so my comments this morning are going to, first of all, talk about some of the potential impacts we might see. And I'm going to look at some of the statistics we can draw upon from our experience after the Great Recession in 2008. I actually didn't know that's what that recession was called, but apparently that's what folks are calling it. And hopefully those statistics will give you some comfort for those of you in the healthcare sector. And then I'm going to turn my comments to two particular types of gift agreements, restricted gift agreements and pledge agreements, just to leave you with some things to think about as you move forward in this time of crisis. So moving to my next slide, the impacts on donors and charities. While it's still too early to tell, I think it's fair for all of us to anticipate an economic downturn as a result of COVID-19. We're already starting to see that in differing ways. I think it's also fair to say that the ways in which donors think about giving to charities will likely be impacted. Similarly, the ways in which you as charities and not-for-profits will manage your current dollars and how you approach donors moving forward is also likely going to be impacted. Ultimately, organizations like you might become more concerned about donors walking away from their multi-year charitable pledge commitments, or organizations like you might find that the restrictions that are imposed upon gifts that are currently on your books are posing challenges on what you actually need to be funding and how much you need to be doing that. You might also find that the nature of what donors want to support is going to change in the context of this crisis. So turning to my next slide, in making these general observations about what we might all expect to happen to our donor bases, I was curious to see whether there was any empirical data that would provide us with some evidence to support those observations. While it's based on a US data, a study done by the Russell Sage Foundation and the Stanford Center on Poverty and Inequality during the last recession, again called the Great Recession, found that between the years of 2007 and 2010, there was a drop in charitable donations in the US of just under 10%. And that drop was from roughly $327 billion to about $291 billion. There was, however, a bit of a silver lining in that study, in the sense that while overall donations dropped, the percentage or proportion of people's income that they contributed to donations didn't. In other words, society's willingness to donate, even in an economic downturn, didn't change. The issue was because people's income and means declined, the overall quantum of donations declined, although they were still donating in the same percentages. And in Canada, if you look at the statistics in terms of the impact on the last recession, we did also experience a drop of about $500 million in charitable donations during that same time frame. So leaving aside the impact on donations due to the economic uncertainty flowing from COVID, the other thing I think we can expect to see is the changes in the ways donors are going to want to fund. And this too is supported by the data from 2008. We saw an increase in support going to crisis-related sectors like food banks, employment services, credit counseling, and mental health counseling facilities. There's also good news for you folks here in the healthcare sector. In the 2008 recession and the period of time immediately following it, charities and nonprofit organizations in your sector accounted for the second highest level of donations between the years 2007 and 2010. So again, there's a bit of a silver lining for you folks. And I can tell you anecdotally, in dealing with clients in my high net worth client practice, we already are seeing a change in where people are wanting to focus their philanthropic donors. People who might have been focusing on the arts or focusing on the environment are now looking at where is there going to be the greatest need coming out of this crisis, and they're looking to earmark donations to those organizations. And hospitals and PPE-related initiatives are top of mind. Turning then to my next slide. So while we might see a decline in overall charitable funding, you in the healthcare field, I think, are going to benefit the most from fewer dollars. But what if this doesn't turn out? Or what if your needs change or they increase? What does that mean for you? Well, it may mean a need to look at your donor agreements to see what flexibility there is in them. And it may result in a need for you to revisit some of those pledge agreements. You might be faced with a donor, for example, that comes to you and says, look, I know I made this commitment to donate $100,000 every year to you for the next 10 years. My business has been drastically impacted. I'm either not going to be able to satisfy the balance of those payments. I'm in year 5 now. I'm not going to be able to make the balance of those payments, or I'm going to have to ask you for longer to make those payments. Can you turn to my next slide, please? Actually, skip to 2 from the next one as well. So with that backdrop, where does that leave all of you who rely on charitable funding? I think it leaves us looking at the different types of donor agreements. And obviously, from your perspective, the best type of gift to receive is one that is unrestricted. So there are no terms imposed on how you can use the funds, and one that is fully paid to you in one installment rather than pledged to be paid over a number of years. Unrestricted gifts are really useful to organizations like yours, particularly in the context of a crisis where unexpected contingencies may arise, your needs that you need to support may increase, they may change, and there might be that all coupled with a downturn in donations. As I said, a bit of a perfect storm. But while unrestricted gifts are common, they do not typically make up the largest portion of any charity's donor base. The most significant component of a charity's donor base, in our experience, comes from agreements, comes from donations that are structured in some fashion pursuant to some agreement. It comes from arrangements that are pledges over a period of time. And typically those arrangements are documented. And if they're not, we typically recommend that they should be documented. So leaving aside unrestricted gifts, donor agreements become particularly important when donors are making restricted gifts. And that's because the document will actually articulate the relationship between you and your donor. Ultimately, what the purpose of the agreement is, whether it's for an ongoing gift or with respect to a one-time gift that's going to be subject to terms and conditions, it's really intended to avoid issues that might arise in the future. Unfortunately, those terms can also pose challenges for you in the context of a crisis, where your potential needs might change, either in what you need to be doing with your charitable dollars or how much you need to be doing to support those charitable purposes. Turning into my next slide, as I said, from your perspective, unrestricted gifts are the best. It's basically you're free to do with that type of money as you see fit. But that's not the most common type of funds each of you receives, and it's more than likely your largest donations are coming pursuant to some form of restriction, some form of agreement. And there are 2 general types of restrictions we see in the agreements we deal with on behalf of our clients. First of all, there might be restrictions imposed on the purposes or activities that you can use the donated funds for, or there might be restrictions imposed on how you can spend the money that the donor has given to you. And each of those restrictions can present challenges, particularly in the midst of a crisis. First of all, the particular need that you've got to address today might not actually fit within the parameters of the purposes or activities as articulated in the agreement. Or your needs might fit what the donor wanted you to do, but there might be limits on how you can spend the money, which is out, and your needs are actually outstripping those limits. And I want to speak a few minutes about what restricted gifts mean in terms of you finding yourselves in those situations where either the purposes don't work anymore or the quantum doesn't work anymore, and leave you with some tips to think about. So turning into my next slide, restricted purposes. In terms of restricted purposes, they can vary both in scope and detail. You can have restrictions that really aren't restrictions at all, in the sense that a donor is really allowing you to support a very broad range of purposes. For example, to provide financial assistance to Hospital Foundation Y in support of COVID-19 related efforts. That can be fulfilled by a very broad range of activities, from buying PPE, increasing your staff, supporting research. Or a donor could be very specific and say, to fund research into the finding of a vaccine for COVID-19. Obviously, only certain activities can be carried out to fulfill that purpose. The general rule of thumb when looking at the restrictions in your agreements is that the more specific the purpose, the more challenges that will present to a charity or a not-for-profit when there are changing circumstances to address. And that's because the more specific a purpose that's stipulated in the agreement, it really was intended to address a particular need, And that it's often the case that that need doesn't mesh with the changing circumstances that you folks may find yourselves in. Like restrictions on the use of funds, limits on how the funds can be spent can also be broad or narrow. The most common types of limits we see in terms of expenditures are of three different kinds. First of all, there might be restrictions on how income can be dispersed, income that's generated on the donated amount. There might be restrictions on whether capital can be spent, whether you can dip into the original capital amount, and if so, when and how much. And then the last type of restriction that we commonly see is with respect to how long the capital needs to be held by the charity before it can be touched. And the most common is a perpetual concept where you've got endowed funds. Other terms that we see are 25 years or 10-year holds. But in essence, the idea is the same. You can't touch the capital within that stipulated period of time. The other important distinction to have to sort of pay attention to in your gift agreements is with respect to the meaning for income and capital, because they are slightly different. And the differences arise between what does income and capital mean for property or gift law purposes, and what does it mean for tax purposes. And often those two worlds don't come together. Capital, from a property perspective, is the original donated amount that gets invested by the charity. And the income is the investment returns that get derived from that invested capital. We always analogize to the fruit tree. Capital is the tree, and fruit is the income. The problem is, I'm sure all of you understand that income from a tax perspective would capture things like interest income that's generated or dividend income, but it also captures realized capital gains from a tax perspective. And that poses a challenge from a property law perspective, because realized capital gains are capital. So if you are looking at a donor agreement and you don't have a special definition for income to capture realized capital gains, as your charity buys and sells stocks that might be subject to one of these restrictions, you may not be able to access realized capital gains, and that might pose a limit on you in terms of you being able to support the needs that you do. The other challenge we see here is with respect to the principles that apply to accumulating income. If you earn income on the invested donated amount and you don't spend it all in a year, from a property perspective, the excess income gets accumulated and it is capitalized. It becomes capital. So again, unless your donor agreements expressly sort of carve out unexpended income in a year and allow you to dip into it, you may not be able to touch it. And so that's something you want to look at in your gift agreements that you've got on your books right now, but also moving forward if that's something you haven't otherwise been sort of focusing on. Turning to the next slide then, what does this mean for all of you? What are the consequences of these restrictions? Because ultimately, from your perspective, whether these restrictions in donor agreements that are on your books today are a problem is really going to depend upon the nature of the restrictions, because it's the nature of the restrictions that will determine what your obligations are and determine what your rights are. And there are really two different buckets of restrictions that we typically see in donor arrangements. And they range from one side of the spectrum to the other. There are what we describe as precatory restrictions, and these really aren't restrictions at all. They really are non-legally binding expressions of the donor's wishes as to how the donated funds are to be used. But just because they aren't legally binding doesn't mean they aren't morally binding or considered to be morally binding by the donor. And it doesn't mean you don't have donor stewardship issues to think about if you want to change how you expend funds that are subject to these precatory wishes. And the most easiest example of this are donor advised funds. They really are sort of an expression often of the wishes the donors want you to do when expending their charitable dollars, but they're non-binding. But as I say, donor stewardship issues may actually be a more paramount consideration for you, and it may actually lead most charities to treat these precatory wishes as obligations. On the other side of the spectrum are charitable purpose trusts. If the restrictions in your gift agreement create what is legally a charitable purpose trust, then you are under a legal obligation to follow the restrictions. In essence, the board has taken on the obligations, the fiduciary obligations of a trustee. And so compliance with those restrictions is mandatory, and risk attaches to the charity if they fail to comply with those restrictions. So this sounds pretty easy. We've got agreements that might be subject to precatory wishes, and then we have the other end of the spectrum, agreements that might be subject to charitable purpose trust arrangements. And that is the threshold issue. What type of restriction has been imposed by the donor in your agreement? And I'm not going to spend time today getting into the legal requirements that get you to a charitable purpose trust. Suffice it to say, that is the threshold issue that you need to sort of grapple with when you look at your donor agreements. And if something meets a charitable purpose trust, then as I say, you've got obligations to abide by, and there is consequences in the event you don't abide by those obligations. And I'll come to those in a minute. Because I think in the context of changing needs, whether that's in the context of you're looking at an agreement and the purposes don't quite fit what you need to support today, or you actually need to tap into more money, you're going to want to start to think about, well, what can we do in the context of the parameters of the donor agreements on our books? And then it comes to, from the perspective of risk assessment. And turning to the next slide, the last bullet on this slide, really, what are the issues if you fail to comply with restrictions? And there are really sort of three buckets of potential risks to think about. First of all, the donor could launch a claim for breach of trust. And if that claim is successful, it may result in the board being subject to liability to, in essence, return the funds because they spent them in a way that wasn't permitted pursuant to the donor agreement. Or the donor could bring a claim for negligent misrepresentation in terms of what the charity said it was going to do with the funds. And again, that poses risks of liability for the board and the charity. More importantly, though, are reputational risks. And at the end of the day, that is probably every charity's strongest asset. A donor could also file a complaint with the public guardian and trustee, or if it's the public trustee in your jurisdiction, with the public trustee. And that could lead to an accounting obligation. And those obligations are time-consuming, expensive, onerous, and frankly, a bit of a pain to deal with. Or they could whistleblow to the CRA in some manner, and that could lead to an audit that you weren't expecting. Not that you ever expect to be audited. Or lastly, the donor could engage in perhaps what most of us are more worried about in today's social media age, a social media campaign aimed at maligning the charity in terms of how it's dealing with its donors. And I hazard to say that the court of public opinion might in fact have more sway than the judicial courts that all of myself and my colleagues are more familiar with. So moving to the next slide, what does that mean for all of you? You've got donor agreements on your books. You've looked at them. The purposes don't quite match what you need to do. You can't spend the money that you'd like to in terms of the income definition that's in the document. What is it that you can do? The first thing we would suggest you do is look at the terms of the agreements to see whether they can be amended to allow you to be able to do what you want to do. Again, here though, the nature of the restrictions will determine whether you can amend the agreements you have. If it's a precatory type of document, a donor advised fund, for example, they probably won't have any provisions dealing with amendments, and you're probably going to be free to be able to amend those wishes because they're not legally binding. But again, donor stewardship issues and your ongoing relationship with your donors are going to be a consideration you're going to want to trip through, even in the context of precatory documents or documents with precatory wishes, because you want to make sure that you're protecting your donor base moving forward. And if they see you sort of tweaking even unrestricted gifts where they express some wishes, they might sort of stop making donations moving forward to you. Moving then to charitable purpose trusts. Here's where things get a little bit more challenging for you. Absent an express power in the agreement to amend the terms, you can't unilaterally amend the terms of a charitable purpose trust. So you first want to look at the donor agreement and see if there is an amending power in it. And often those types of donor agreements allow the charity, either through a consultation process with the donor or a representative of the donor, to amend charitable purposes that are stated in the document if they've become impossible or impractical to carry out anymore. So if you've got that power in your agreements, great. But if you don't, all is not lost. There still is the option of bringing an application to the court to vary the terms of the charitable purpose trust that's been imposed on you. And that, in essence, you're asking the court to approve the variation. It's typically going to be made under Section 13. You can go back 2 slides, sorry. Thank you. It's typically going to be made under Section 13 of the Charities Accounting Act, and it's going to involve either the public guardian and trustee in Ontario or the public trustee in other jurisdictions. And if you're looking to vary the purposes, you're likely going to be asking the court to apply or grant you what's called a CPRE order to allow you to apply the funds as near as possible to the original purposes that is consistent with the donor's original intentions. If you're looking to change the way you can spend the money, the expenditure rules in the agreement, you're relying on the court's what we call scheme-making jurisdiction, because ultimately the court has an inherent jurisdiction over charity and charitable property, and so that's why the court has a role to play in amending charitable purpose trust if there isn't a provision to allow you to do that. Terry is going to pick up with some other comments about restricted gifts, particularly the new PGT policy, and so I'm not going to speak any further about restricted gifts. I'm going to move to the other types of agreements that might be on your books that you might be worried about, and that's pledge agreements. So turning to my next slide, pledge agreements are an agreement basically where a donor has come to you and said, as I said earlier, I'm going to pledge to make a $100,000 gift to you over the next 10 years. And now they've come to you, it's year 5, and they said, look, I'm not sure I can make any more payments. I either need to stop them or I need to put a hold on them, but you might get the money at some point in the future. It's really a promise to make certain gifts over a period of time. The problem from your perspective is you might actually see those dollars as committed already, and so you might begin to worry donors might start to make those asks, or you might begin to worry that donors are going to make those asks. And so that might then have you looking at your charitable pledge agreements to see, well, are they as strong as I'd like them to be, and what do I do if a donor actually makes this request of me? Unfortunately, the enforceability of charitable pledges is a complex issue, both legally and, again, with respect to donor management and public image consideration. The law in Canada is complicated, and it's not as supportive as other jurisdictions in terms of taking the concept of a charitable pledge and actually treating it as a binding contract between the donor and the charity. Other jurisdictions are far more supportive than Canada is. In Canada, what makes a charitable pledge an enforceable contract at law, as opposed to what we call a naked promise, is the donor has to receive some form of consideration for making that pledge. In other words, they have to be getting back a benefit to agreeing to commit to the pledge. That complicates things from the perspective of what is a gift at law, because in order for a charity to be able to issue a receipt, they can only issue receipts with respect to gifts. And a gift at law is a voluntary transfer of property without consideration. So prior to the introduction of the split receipting rules under our Income Tax Act, there were some definite challenges with pledge agreements where you wanted to show there was consideration to the donor beyond sort of naming rights if that wasn't relevant, but you were also in a situation where the donor wanted a receipt. And so there were some challenges, as I say, prior to the split receipting rules, which aren't really new anymore. Turning then to the enforceability, these are the 3 things that you want to look for. Thank you. These are the 3 things, the 3 bullets here are the 3 things you want to look at or look for in your pledge agreements. Has the donor or has the pledge agreement been structured to provide the donor with some form of consideration as a condition of making the pledge, naming rights or something else? Naming rights, though, are typically more common in capital campaigns, and so again, it depends upon the context of what the pledge agreement was given for. You want to look to see if the pledge agreement was under seal, because at law, the concept of a seal does indicate a form of consideration. It goes back to some very, very old legal principles. And then lastly, you want to look to your agreements to see if there's some statements about how you have relied on the pledge payments, including all of the ones that actually haven't been made to you yet, and how you've changed your position in terms of what you've done internally by relying on the whole kit and caboodle of all of the pledge payments. In other words, you're trying to support the argument that you have detrimentally relied on all of the pledge payments, even the ones that haven't been made at any particular moment in time. And if you have those three things in your agreement, you're in a pretty good shape from a legal perspective, although it's not absolutely certain. Again, the most difficult issue here is your donor relationship. If you have a donor coming to you saying, look, I just can't do it in the context of COVID, I'm trying to keep my business together, you really are in a situation where you've got to make an assessment. How far do we push the enforceability issue with the potential risk that we lose this donor forever, and maybe we lose other donors because, you know, this donor tells two friends, and so on and so on and so on. And so it really is a bit of a delicate balancing act in terms of weighing the pros and cons of enforcement issues. So coming to my last slide and sort of coming full circle, all of you will have, I'm sure, restricted gift agreements on your books. You probably have pledge agreements on your books. If you're facing increased needs and reductions in your new dollars, you might want to start looking at those gift agreements, having a better understanding of the restrictions that are imposed on you, both from a purpose perspective and a spending perspective, all with a view to understanding, are these arrangements actually going to fit what you need to be doing moving forward? If they don't, have a look to see whether you can amend the terms of those restricted agreements. If you can't amend, you can give consideration to bringing a court application. Again, you want to do a cost-benefit analysis because every court proceeding, it costs funds, it costs aggravation, and it takes time. And layering on top of all of that is your relationships with your donors. At the end of the day, your most significant asset, if we can move forward to the last slide, at the end of the day, the most significant asset all of you have as charities and not-for-profits is your reputation in terms of how you deal with your current donors and how you deal with future donors. So I don't think I have any questions, but I'm just gonna, nope, I don't have any questions, and those are the end of my comments. Thank you for listening.
Thanks a lot, Corina. That was really a great refresher. Certainly some lessons there that we all should take advantage of, going back and checking our agreements right now and having consideration to many of those concepts as we enter into agreements right now. Also really great to reflect on the history of the Great Recession, as you called it, and there were certainly some lessons there to be learned. Now we're going to hear from Terry Carter. So Terry, as you all know, is the founding, named, and managing partner of the Carter's Law Firm. He is one of the preeminent charities and not-for-profit lawyers in Canada. You will all know the work that he does. He is co-author and co-editor of 2 leading texts on not-for-profit and charities law. He's an advisor to the Canada Revenue Agency, the committee that they have on issues relating to the charitable sector. He's the past chair of the Canadian Bar Association and the Ontario Bar Association groups on charities and not-for-profit law. He's recognized as leading expert by Lexpert, the best lawyers in Canada, and Chambers and Partners. So he brings so much experience, and I'm sure we're all going to benefit from his remarks about what board members should be considering from a due diligence perspective during this current pandemic crisis. So Terry, over to you.
Well, thank you very much, Lynn, and again, delighted to be with everyone today. I can go to the first slide and just indicate the slides do have a lot of content in it because I may not be able to cover everything in my comments, but you'll have a resource tool to go back to, and it'll also cross-reference to other publications at our website of carters.ca. I just encourage you to take a look back there for more information. If you do want to get on our website, you are required to click and provide consent for it. It does not come automatically as a result of registering for the seminar, so just keep that in mind. So what I'm going to do in the next 25 or so minutes is sort of walk you through some of the considerations that we take into account when we're advising directors and officers of charities in responding to the COVID-19 situation. So it's going to be 14 different areas, really tips, issue identification for you to be aware of as either you go back to your boards or you work with your organization. But obviously we can't drill too deep into any of them, but a board of directors really need to be aware of what the legal issues are. So what we're going to be doing is focused on some of the legal considerations that board members need to have. You're having to make very quick decisions, almost sometimes spur of the moment. And so what follows are intended to be sort of guideposts for you to use as you do your work. I have a lot of respect for directors and officers, particularly directors, because they're not paid. Everyone else gets to be paid in an organization. The advisors, the lawyers, the accountants. It's the directors at the end of the day that have the responsibility. They have a fiduciary duty to keep the organization going. And so to the extent that we can help to equip the board to be able to do their job well, I think that we've assisted in charities in the healthcare sector dealing with the COVID-19 situation. Next slide, please. So what are the responsibilities that directors and officers have when they're looking at responsibilities? And basically, the legal responsibilities are reflected in the two concepts that are up in your slide. One is a fiduciary duty, and another one is a duty of care. Fiduciary duty, in my mind, is always very simple. You put the best interest of the charity ahead of your own. You're only thinking of the purpose. It's all about a passion for the purpose will drive you in the decisions that you need to make. And secondly, the duty of care is that of a prudent person. A prudent person doesn't mean that the individual has to have all the knowledge base that you have, and you might have some specialized knowledge. It's meant that your duty that you have in performing your fiduciary duty needs to reflect that of a prudent person. And that takes us on to the concept of the business judgment rule, and I think that's an important one to keep in mind. You're not expected as directors and officers to be perfect. You're not always going to be making the right decision. But as long as it's reasonable under the circumstances and you've taken into account the considerations you need to look at, that fulfills your duties as directors. So it's not the standard of perfection. So we're going to be focused today primarily, I'm just going to take a look here in relation to a note about paper. So I will be very careful not to create a paper noise. Thank you very much for that. So we're going to be focused primarily on Ontario law, but it's going to reflect common law principles across Canada. So the next slide, please. I want to talk now about some of the due diligence considerations. First of all, keeping records of decisions. You know, during this period where you're having to make very quick decisions, sometimes you can forget to document what you're doing. And I think the takeaway here is that you need to be able to show that the due diligence has been done. The way that you do that is to be able to record the thinking that you've had as directors and officers, the considerations, the input, and most importantly, the decision-making that's done at the board of directors and the minutes that you keep. Sometimes there's appropriateness in having very short minutes. I think during a crisis situation, it's helpful to have more detail with regards to the minutes that you have. Next slide, please. Next, you need to make sure that you're meeting as a board. You need to be engaged. The board has to be making the tough decisions, and that means that you have to meet on a regular basis. Charities, healthcare charities that normally meet maybe 4 times a year may want to reconsider to meet on a monthly basis in order to be able to make the decisions that are required. You need to determine how you meet. If you're a board, can you meet electronically? Can you meet by telephone? You need to take a look at your corporate documentation with regards to that. You need to make determinations of when your members are going to be able to meet for their annual members meeting, which Jackie has talked about in some detail. And you need to make sure that you're tracking your corporate filing dates. And again, Jackie's presentation is very helpful in that regard. Next slide, please. Next, you need to have a focused communication strategy. It's essential that you identify the different audiences that you have, whether it be members or staff or volunteers or folks that you work with in the community. And then ensure that your communication is open, is transparent, and is timely. But I think the key takeaway here, it's important to have one person to be that key individual providing communication on behalf of the healthcare charity. And whatever communications that you do put out, again, it's evidence of due diligence, so it's important to be able to keep records of the communications that you're putting out to your stakeholders. Next slide, please. Well, this is a tough one. In keeping up with government actions, I used to watch the Prime Minister every morning at 11 o'clock. I gave up some time ago, but I wanted to be on top of everything that was occurring. And now things are changing so fast at federal level and provincial level and health authorities. And now with stage 2 and the reopening occurring, it's just an avalanche of information and government requirements in place. You as board members need to stay on top of that. You cannot rely upon your management to do that. You as board members need to do the appropriate tracking of the government requirements. It is a changing landscape. It is difficult to keep up. It's difficult for the lawyers to keep up. I'm challenged at times. And so we have at our website resource materials. Frankly, I primarily use it for myself to remind what's happened on an evolution basis over the last 3 months. So feel free to acknowledge the fact that you don't know everything, but you need to make an effort to try to keep up and look at your particular sector area to continue to be familiar with it. Next slide, please. You need to look at your crisis management policy. If you don't have one, well, this is a good opportunity to have one. If you do have one, you're probably going to have to review it and revise it. I know that we've done that as a law firm. I was working on a crisis plan back in February, and obviously we got pushed to the test, and it's gone very well, but you have to be able to modify that. And so when you're looking at a crisis management plan in place, you need to look at succession. Succession not only of board members, but succession dealing with management. What happens if that key CEO decides to move on? What happens if you can't afford to have some of your management team in place? So it's not just a matter of replacing a key individual. Sometimes you have to make do by spreading those responsibilities over to other individuals. And then probably the most important aspect to take away is reviewing your insurance policies. You need to know what you have, and you need to know what you don't have. Insurance is a contract. Insurance does not cover everything. As we're finding out with business interruption insurance, there's a lot less than organizations thought that they might have had in place. But the insurance industry also it's a business. And so they're careful in what they cover and they don't. And so when it comes down to COVID-19 related risk, you need to have a conversation with your insurance broker. Write to your broker, ask your broker, what do we have in relation to coverage for COVID-19 type claims, which can be very broad. And who's covered? Does it include volunteers as well as clients that we work with, as well as employees? And then what are we not covered for? You broker, you understand how we operate. You understand our risk. And if they don't, set that out in detail to them and ask for their advice. because insurance brokers are a profession, and you should be able to rely upon the advice that you're getting and make decisions in accordance with it. But you must do that in writing. And then the board needs to evaluate the information that you've received back from your broker, and you may have to adjust some of your programs and activities accordingly. And if you're not sure about the terms of the insurance, then work with your legal counsel or those lawyers who can read insurance policies. It's a surefire, fun thing to do. Next slide, please. Then you need to look at your contractual obligations that you have, whether it be for conventions coming up or obligations to perform. Read your contracts. And some of those contracts will have provisions that deal with force majeure, which some suggest might be able to get you out of a contract, and others suggest maybe not. It's going to be debate in the courts for years to come. Read your contracts, get legal advice, because you may be able to negotiate on a without basis some relief from the terms of the contract based upon what's there, whether it be dealing with force majeure or frustration of contract. We have a resource tool that's at the bottom of that slide that can help you in that regard. Next slide, please. Financial matters. Corina talked about it. You're going to have less money coming in the door. That is just the reality. Imagine Canada did a report indicating that charities in general are down 30% in income. Industry by industry, there's huge fluctuation. Many charities are now facing closure or massive retrenchment. This is an existential moment for some charities. And therefore, it's essential that the board be familiar with what the financial status and the health of the organization is in looking at income sources that are there or not there. And then to make appropriate decisions in response to the recalibration of income that is being received. Jackie's talked about reliefs that's come in, that's great. But remember, the relief is not going to be there forever. And so the board needs to anticipate short-term income as well as long-term income and make some difficult decisions with regards to the charity. The charity is there for the purpose. It's not there for the person. And so you may have to make some difficult decisions with regards to the team members that you have. As unpleasant as that is, you must keep focused on achieving the purpose. Work with your employment counsel to be able to work through what are the obligations that you have with your employees. In that regard, over to the next slide, please. As board members and managers, advising directors, I'm always mindful of the fact that there's personal liability that directors have, in general terms, for unpaid wages up to 6 months. And if you're looking at the possibility of having to let folks go, not just temporary layoffs, then you need to factor in the ability to cover those expenses as well. So the responsibilities that you have not only is for the wages, but also for source deductions, because your friends at the governments will be mindful of your obligations as directors to pay it if the government does not receive it. Next slide, please. Next, the board needs to be aware of workplace health and safety considerations. The big topic, Laurie's going to be talking about it in some detail. Number of slides here will give you some background resource materials, which I won't spend too much time on, other than to say, in Ontario, when you look at the Emergency Management and Civil Protection Act, it does cross-reference to other statutes, occupational health and safety, as well as public health official instructions that come through. Your job as directors and officers is to be familiar with it. Next slide, please. And with regards to that, this slide, as well as the next slide, please, talk a little bit about the obligations that you have as a charity with regards to your employees and as well as with regards to the public. And again, Laurie will be talking about that in more detail. So next slide, please. What I do want to mention, though, with charities that are working with the public, there is an act in Ontario called the Occupiers Liability Act that basically imposes statutory obligation upon property owners and operators with regards to the safety when the public and others are being admitted to those facilities. Important to be familiar with it. There can be a civil liability that arises from it. And that takes me into the comment about volunteers. We often focus on employees. Volunteers are in essence like employees, because whatever volunteers, and we're so thankful for our volunteers within the healthcare sector, but if they make a mistake, then there's vicarious liability that flows back to the organization. And the healthcare charity has an obligation to the volunteers the same way that it does to its employees. And so it's important to ensure that there's protection in place for your volunteers. And it's also important to ensure that you're monitoring what your volunteers are doing, because they're an extension of your healthcare charity, and it's essential to ensure that appropriate protocols are in place. Next slide, please. Another consideration for directors and officers to be aware of, and you don't have to become an expert, but you need to be aware that privacy is a huge consideration, particularly during a pandemic. If you don't have a privacy policy, you need to have one. If you haven't updated it in the past few years, you need to update it. Privacy is a huge consideration because you're dealing with personal information of individuals. And so this slide here sets out basic obligations that you have, basic expectations that when personal information is being obtained, it's there for a purpose, it will be properly protected, and you will be having appropriate due diligence concerning how long you keep it for and how you may destroy it at a later time. Next slide, please. When it comes to the reality of the pandemic, when we have so many people, staff, and even volunteers working at home, it does point out the reality that there are greater risks associated with breach of privacy when you have remote operations. And therefore, your remote work policy should be upgraded to take into account considerations that need to be thought through. We've given you some of those on this particular slide. They're reflective not only what we do with our clients and advice to them, but also reflective, frankly, what we do as a law firm, because we have most of our lawyers and staff working remotely. You are going to be accountable if there are data breaches that take place. Therefore, working with your IT team, get a report at a board meeting, find out what they're doing, find out the extra steps that have been taken, and have it documented. Remember, you're not responsible for perfection, but you are responsible to show that you've been reasonable in taking appropriate steps. Next slide, please. And then if you're having meetings via video conference, you've all heard the horror stories dealing with Zoom and others where it has resulted in data breaches occurring. So you need to have protocols in place, particularly if you're having board meetings where there are sensitive matters that are being discussed, to have appropriate protocols in place. Next slide, please. Corina did a marvelous job in talking about restricted gifts, and I want to just bring you up to speed with a development that's occurred here in Ontario. To the credit of the Public Guardian Trustee's Office, they took the initiative at the end of March, knowing that some restricted funds could be of help to charities that were facing an existential moment of potentially closing down. And they came up with a very helpful guidance. And on April the 20th, they came up with a Q&A that talks about the policy. And that's what I'm going to speak about now. If you do want some more information, we have a bulletin on our website that sets out the details for that, that's referenced in the next couple of slides. Well, what can you do? Well, if the charity is in danger of closing, it's now possible to be able to access income and capital of restricted purpose funds that Corina talked about, whether those restricted purposes be restrictions on usage, maybe a building fund, or restriction on time, maybe an endowment fund. If you do have a real restricted purpose as opposed to a precatory trust that Corina talked about, then instead of having to march off to court to get approval to dip into those funds, the guidance provides some flexibility. It does have a number of conditions associated with it, but it does show a flexibility by the Public Guardian Trustee's Office, which I think is been a good development. So when can you dip into restricted funds? Well, again, read the guidance very carefully, but in general terms, you're able to access those funds if it's a matter of last resort. If you've sourced out your other reserve funds or non-restricted funds, as well as government funds, and you're still facing, next slide, a potential closure, then you're a candidate for it. What does potential closure mean? It doesn't mean that you're facing immediate bankruptcy or receivership, but the Q&A suggests that if you're looking at the inability to operate within 30 to 60 days without getting funding, then you would be a good candidate for it. The funds, however, have to be used for basic operations as well as for COVID-related matters. And you have to notify the Public Guardian Trustee in writing ahead of time. They do have the ability to be able to review matters at a later time, and if they're not satisfied, next slide, that you have been reasonable with regards to your encroachment, that can be problematic. Problematic because you can be held responsible. So you want to document what you're doing in accessing the funds. You want to get a unanimous decision by the board of directors to do so, and then document then how the funds are being used at a later time. Next slide, please. Another consideration during a pandemic is management of your investment funds. Fortunately, the market has sort of bounced back, but who knows, we may be going into a second wave and we may have some continued volatility. If you're in Ontario, you want to have an investment policy, and you want to make sure that it's not simply from a bank or an investment company. Get your lawyer to prepare it in accordance with the Trustee Act, because it sets out requirements that need to be taken into consideration. The Trustee Act is helpful because it does provide protection to directors from liability if decisions have been done on a reasonable basis in accordance with an investment policy. So that's a good incentive for you in that regard. Over to the next slide, please. Use of audit committees. If you don't have an audit committee, good time to get one. Normally, audit committees are restricted in dealing with financial statements preparation, corporate reporting, and risk management. I think an audit committee can be very helpful with regards to documenting the due diligence consideration on the tough decisions that need to be made, as well as providing evidence of follow-through. So this is a good role for an audit committee to become more robust than possibly they may have been in the past. And finally, next slide, please. I want to talk a little bit about solicitor-client privilege. You know, discussions that take place can be confidential, but that doesn't mean that confidential discussions amongst individuals can't be the subject matter of disclosure during legal proceedings. However, if you have discussions with your lawyer, those discussions, when you're seeking legal advice, will be protected from disclosure in the event of legal proceedings. That's called a solicitor-client privilege, and can be very important with regards to discussions about compliance with regulatory requirements, matters dealing with potential litigation. So when you talk to a lawyer and you're getting advice, not only is it confidential, it's privileged. It's very powerful. And other professions do not have that available. Accountants don't. So when you're talking with your auditors, it is not privileged communication. So as a result, if your board is dealing with tough decisions, consider bringing in your legal counsel, document what you're doing. If you have to bring in other professionals, maybe like an accountant, then have your lawyer bring that other professional in under solicitor-client privilege. However, ensure that you do not waive the privilege by sharing that information with others. It's important to protect it. And if you do have discussions at board meetings, making reference to legal advice, ensure that you're documented in your minutes as being solicitor-client protected. So those are some thoughts that I had. Next slide. The ever popular disclaimer, you know, that's sure a crowd pleaser for sure. It gives you just some ideas of the considerations that we wanted to pass on to you as board members and senior management concerning due diligence considerations during a pandemic. And Lynne, we're able to keep on time because I don't see any Q&As, which is just great. So I'll turn it back over to you, Lynne. Thank you very much.
Thank you, Terry. You're right. No questions from the audience. I'm going to pose one to you, though, and that is this. What is the question that charities are calling you about most right now because of COVID-19?
Lack of money.
Hmm.
Lack of money, and they're facing the existential issues. How do we keep going? And you know, part of what the sector is doing is putting pressure on the government. The sector needs money, and they need it now, and they need a lot of it, because if we don't have the voluntary sector, both charities and not-for-profits in place, we're going to be suffering as a nation. And I don't think there's enough consideration being given to the charitable sector and the need for it. So to the extent that folks on the call can support the initiative by Imagine Canada and by others to write to the federal government to tell them this is the time and there needs to be considerable funds put in place for the charitable sector.
Thanks, Terry. Okay, so our last speaker is my partner, Laurie Turner. Laurie is my right hand in the corporate health practice group at Fasken's. She's a partner. She works mostly with for-profit and not-for-profit entities on a diverse range of matters, including corporate restructurings, governance, mergers and acquisitions, procurement, and privacy. Laurie's going to speak to us about some more practical aspects of the COVID-19 laws, particularly as they relate to your employees. So Laurie, over to you.
Thank you very much, Lynne. So as you saw, my topic is advancing your health mission during COVID. So in planning for the presentation, I sat down to consider what really is essential for organizations to continue to push forward through this time. And from that exercise, 4 things really jumped out at me. The first being funding, second being employees, third being premises, and fourth, technology. But given that funding has already been addressed in the seminar, and also given the composition of the audience and the time allotted for my presentation, I decided to choose to focus on 2 of these. So I'll focus on employee and premises matters. Before proceeding, I also wanted to say that I'm covering a lot of topics today, many of which in and of themselves could form an entire presentation on their own. So my summary will be a high level only, but if you require any additional assistance or if you have any questions following the seminar, we welcome you to reach out to us. Next slide, please. You can move to the next slide, thanks. Okay, so first I'll provide a very brief summary of some of the relevant obligations of employees and rights of, high-level obligations of employers and rights of employees under the Occupational Health and Safety Act. The Occupational Health and Safety Act is the provincial legislation that sets out, number 1, the rights and duties of parties in the workplace, including but not limited to employees and employers, and also 2, procedures for dealing with workplace hazards and for the enforcement of them when needed. Under the general duty clause of the OHSA, an employer has a general duty an obligation to take reasonable precautions to protect the health and safety of its workers. With respect to the right of employees to refuse unsafe work, generally speaking, the OHSA gives workers the right to refuse work where he or she believes that it is unsafe to himself or herself or to another employee. However, certain workers are excepted in specified circumstances from this general right to refuse unsafe work. So, for example, the right to refuse unsafe work does not apply to workers at hospitals, long-term care homes, and laboratories where the conditions of the workplace is likely to endanger the worker, but such conditions is inherent in the worker's work or as a normal condition of the worker's employment. In the context of a pandemic, an employer can also expect workers to exercise their right to refuse unsafe work based on what they perceive as inadequate protections. Therefore, it's more important than ever that employers are aware of their obligations and take steps to offer adequate protections to employees. And two, that employers and members of joint health and safety committees and health and safety representatives within the workplace are familiar with the specific procedure that is set out in the OHSA for any work refusal. And I'll turn back to work refusals a bit later in this presentation. Next slide, thanks. Okay. In response to the pandemic on March 19th, 2020, the Employment Standards Amendment Act, or Infectious Disease Emergencies, came into effect. And this legislation established the Infectious Disease Emergency Leave, a new job-protected leave. So employees with coronavirus or coronavirus symptoms, or those who are quarantining, are permitted to take the Infectious Disease Emergency Leave rather than sick leave. Notably, the Infectious Disease Emergency Leave is not time limited, meaning that there's no cap on the number of days that an employer or an employee can take on this leave, unlike sick leave, which is generally limited to 3 days. The Infectious Disease Emergency Leave is also available in circumstances other than when the employee is sick or quarantining. So for example, this leave is available where an employee must attend to a sick family member, or where they have childcare obligations at home, such as where their child's daycare has closed as a result of the pandemic. An employee cannot be terminated for taking this infectious disease emergency leave. As I said earlier, it's job protected. So the benefit of this new leave for employees is quite obvious, but the new leave can also have or also be of assistance to employers, including in discharging their duties under the Ontario Health and Safety Act to take reasonable precautions to protect the health and safety of their workers. This is because the new legislation permits an employer to direct an employee to take the infectious disease emergency leave where the employer has a concern that the coronavirus could be spread within the workplace by the employee. Workers or employees must then have to be restated once that concern is alleviated. And later in this presentation, I'll provide some additional considerations for employers prior to directing an employee to take an infectious disease emergency leave. Also of note is the fact that when employers temporarily reduce or eliminate the hours of work for non-unionized workers for COVID-related reasons, such employers are also deemed to be on the infectious disease emergency leave. Regulations introduced under the Employment Standards Act provide that non-unionized employees are not considered to be constructively dismissed in such situations, meaning that an employer is not deemed to have constructively dismissed a non-unionized employee where such employee's hours have been eliminated because of COVID-19. Next slide, please. Okay. So once the Ontario government classified the COVID-19 pandemic as a provincial emergency, sweeping powers under the Emergency Management and Civil Protection Act, or EMCPA, were triggered. At a very high level, the EMCPA provides that during a declared emergency, the Lieutenant Governor and Council, or LGIC, and Premier in certain circumstances may make orders that he or she believes are necessary and essential in the circumstances to prevent, reduce, or mitigate serious harm to persons or substantial damage to property, if in the opinion of that person, it is reasonable to believe that first, the harm would be alleviated by the order, and second, that making an order is a reasonable alternative to other measures that might be taken to address the emergency. So almost 50 orders have been made under the EMCPA since the date of emergency was declared in Ontario. And most of these orders have now been extended to the end of June. So you might ask why this is relevant to today's presentation. Well, it's clear that some of these orders have been made with the intent of assisting organizations in their attempts to continue to move forward with their operations during the pandemic. For example, one order that was made under the EMCPA was an order that was very broad in nature and provided that prescribed health providers, being hospitals, psychiatric institutions, and the University of Ottawa Heart Institute, shall and are authorized to take, with respect to work deployment and staffing, any reasonably necessary measures to respond to, prevent, and alleviate the outbreak of COVID-19. And among the measures that are specifically indicated to be authorized are, and these are examples only, first, changing the assignment of an employee's work, and second, deferring or canceling an employee's vacation, absence, or leave. Notably, the order specifically provides that such actions may be taken despite any other statute, regulation, policy, or collective agreement. And I note that a similar order was introduced to give long-term care homes similar powers at a later date. Another order that is of relevance to hospital attendees is an order which deals with, among other things, credentialing, which is the process for appointing and reappointing members of the hospital's professional staff and determining the nature and scope of their privileges. So the order that was made provides that a hospital's board of directors or the hospital's authorized officers, being the hospital's administrator, CEO, the chair of the MAC, chief of staff, and if there's no chief of staff, the president of the medical staff. These individuals may take, with respect to the hospital's credentialing process, any necessary measure to respond to, prevent, or alleviate the outbreak of COVID-19. The order provides examples of actions that the hospital board or those authorized officers may take, such as appointing or reappointing a member of the professional staff outside of the credentialing process. And they're also able to collect information from professional staff about their likely or actual exposure to COVID-19 and any positive test results or other health conditions that might affect the worker or professional member's ability to provide services. So this order provides that it applies despite any other statute, regulation, or other bylaw. So those of you who are familiar with the professional staff bylaws of hospitals and the hospital management regulation to the Public Hospitals Act have likely identified that the powers that are granted by this order regarding credentialing depart from the process that is set out therein. But as mentioned, this order specifically says that it overrides anything that's set out in that statute or in the hospital's bylaws. You can, yeah, thank you. So next I'm going to speak to some matters that are relevant to return to work and reopening of organizations. You'll see, however, that much of the content is also relevant to organizations who have not closed and who have continued to operate during the pandemic. So the first step seems a bit obvious, but employers must determine first if they can legally reopen their organization based on current government orders and restrictions, and also the province's reopening plan. In most cases, whether or not an organization falls within a category of businesses permitted to be open is clear, but that's not always the case. Second, after determining whether or not your organization is legally able to open, the question then becomes whether the organization can do so safely in a manner that permits the organization as an employer to fulfill their duties under the Occupational Health and Safety Act, including by conducting a hazard assessment for COVID-19. Going down to requisite notice of expected return. So following a determination that your organization is going to open back up, employers should notify those employees who will be expected to return to work. While there's no mandated or legally mandated notice period for this, employers should give employees as much advance notice as possible and at least a few days. Something for employers to keep in mind when reopening the workplace is that unless an organization is subject to an order which requires or indicates otherwise, it must ensure that employees are put back in the same position as they were before they left work, if that position still exists, or a comparable one if not. And failure of the employer to do so can give rise to a constructive dismissal claim. With respect to employees' refusal to return to work, so given the number of employees who have been on leave during the pandemic and the concerns associated with the pandemic itself, it will likely not be too surprising if your organization has employees who refuse to return to work once they're called back. And the organization's response to such refusal will depend on the basis on which the employee is refusing to come back to work. So if the employee is refusing to come back to work because he or she believes that the work presents an unsafe condition, then the organization as the employer will be required to follow the specific work refusal process that's set out in the Occupational Health and Safety Act. And if an employee's work refusal is not upheld by the Ministry of Labor as part of that process, then his or her refusal to return to work may be deemed to constitute a resignation. If an employee refuses to work because of childcare obligations, for example, or because they need to care for a sick relative, then the employer may accommodate the employee and permit him or her to stay home based on the infectious disease emergency leave. And we'll discuss that a bit more later. Next slide, please. So in order to ensure compliance with the occupational health and safety legislation, employers must develop or augment an existing pandemic preparedness policy or program. Notably, the occupational health and safety legislation does not permit an employer to simply rely on its general occupational health and safety policy or program to deal with COVID-19. Whether or not an employer will need to revise or create new policies and procedures in light of COVID-19 will depend on various factors, including its existing policies and procedures, its type of work, and the workplace in which it operates. But in any event, one of the first items of business in the return to work process will be for the employer to determine what policies and procedures need updating, supplementing, or replacing as a result of COVID-19. And examples of some policies that will likely need to be amended are those dealing travel policies and also working from home policies. And then with respect to health and safety training, the law requires employees to provide their workers with information, instruction, and supervision as one of the means by which they protect the health and safety of workers. So new health and safety training offered by employees may touch on matters such as hand washing in the workplace, navigating the office in light of any modifications that have been made to the office as part of the return to work process, and also proper wearing of personal protective equipment or PPE. Next slide, thanks. So in partnership with the Ministry of Labor Training and Skills Development, 4 provincial health and safety associations released a series of 50 technical sector guidelines to further support employers and employees in remaining safe in the workplace during the pandemic. These documents are both general in nature. For example, there's a guidance document for employers in office settings, so very general. But there's also some specific guidance documents. For example, there's 5 guidance documents that relate to the health sector and one that's specifically prepared for the social services sector. And you can access those guidance documents through the link that's provided on this slide. So as discussed earlier, employers have a general duty to take every precaution reasonable in the circumstances to protect their workers. In the context of ever-changing circumstances surrounding the pandemic, what constitutes reasonable can be unclear and can change rapidly based on many factors. But some things to consider prior to reopening your reorganization is whether or not you're going to require your staff to wear personal protective equipment or PPE, whether or not you will ask employees to self-screen, or whether you as the employer will screen employees. Once these questions are answered, it would be prudent to notify the employees of whether or not you're going to do any screening on their return to work, particularly given the high level of anxiety that will likely be present as employees return to work during the pandemic. Such as where keeping a 2-meter distance among employees or between employees and clients or customers is not manageable or feasible, the employer might request that employees wear personal protective equipment. And given the current pandemic, it's generally acceptable for employers to require employees to wear PPE. However, in implementing a policy, employers should take into consideration or give consideration to accommodation, such as respect of those employees who have an underlying health condition, who may not be able to wear the mask and other personal protective equipment, or whose underlying health conditions may be exacerbated by wearing such equipment. Moving down to self-screening, from a human rights and privacy law perspective, it's probably less likely to require employees to engage in their own screening practices rather than for the employer to do so. And one of the benefits of self-screening is that the employee will remain at home during the screening process, whereas they would have had to come to work if the employer is conducting the screening, which might expose other workers to possible COVID. And then employees can also direct employees to the government self-screening tool to do that at home prior to coming to work each day. So with respect to employer screening, one of the questions that has arisen many times during the pandemic is what information employers may ask their employees, such about where they've traveled or their general health. And in the context of the pandemic, given the duty of the employer to take all reasonable precautions to maintain a safe work environment, it's justified for the employer to ask the employee relevant questions about travel and their general health. But later in this presentation, I'll spend a little bit more time talking about employee privacy in the context of screening. With respect to temperatures, temperature testing is somewhat controversial as a method for detecting COVID. This is because it's possible for individuals to have elevated temperatures and not have COVID-19. But because temperature testing is relatively non-invasive, it produces an objective instant result and tests for one of the primary symptoms of COVID, it may be a reasonable method that an employer can use to help mitigate the risk of an outbreak of COVID at the workplace. So some considerations, consider the following with respect to temperature screening. First, screening should be conducted using least intrusive methods available. For example, rather than using contact thermometers, using non-contact infrared thermometers. Second, qualified individuals would need to be available to administer thermometer and to ensure that the test is conducted in a safe manner, such that there's no enhanced risk of employees being infected by each other because of the test administration. Advance notice to workers of temperature checks should be provided. And finally, records relating to testing should not be kept by the employer. So with respect to COVID testing, our firm has done a lot of work in this area. And due to the complexity of this, we strongly suggest that you obtain legal counsel if you're thinking of implementing COVID testing in the workplace. But where an organization has access to test kits, the question that may arise is whether or not they want to test their employers for COVID prior to them entering the workplace. So there are many considerations that can apply in the determination of whether or not to do COVID testing. But a few considerations. First, in Ontario, a license is required to establish, operate, or maintain a place where specimens, which would include specimens collected as part of COVID testing, are collected. So there are some exceptions to this requirement, but it's unlikely that many employers will be able to rely on the exception. For example, an exception exists where the testing is occurring at a place where a physician or nurse practitioner practice his or her profession. So therefore, unless the organization has an in-house physician or nurse practitioner, this exemption is not going to be available to them. And if the testing or collection of samples is occurring outside of a nurse's or physician's office, the test or collection must be requisitioned by an authorized health practitioner. So that means that the employer itself couldn't just request that a COVID test be performed. Third, certain methods of testing, such as when the testing is done by a nasal swab, entail a controlled act, which may be only performed by authorized health professionals, such as physicians and nurse practitioners or their delegates. Again, this means that employers cannot conduct these tests themselves. If, on the other hand, the testing is done by way of a saliva sample and is obtained by having an employee just spit into a tube, then the same requirements with respect to who the testing is done by doesn't apply. So next slide, please. So with respect to rights of employees to refuse testing, employees must consent to being screened. If, however, an employee refuses to be screened, and the employer has a legitimate concern that the employee's attendance at work could put other employees at risk, then the employer could direct the employee to stay home on the basis of the infection disease emergency leave. However, in order for the employer to direct the employee to stay home, the employer's concern must be reasonable and must not be discriminatory in nature. With respect to the rights and obligations of employers when an employee tests positive for COVID, employees are generally required to keep employee health and personal information confidential. However, if an employee informs their employer that they've been diagnosed with COVID or are required to self-quarantine, then the employer should carefully consider the extent to which that information, including the identity of the employee, must be disclosed to others to appropriately protect its workforce. Bottom line, information should only be shared on a need-to-know basis. Some employees, such as those identified as having been in close contact with the positive person, may need to be given more information than other employees. And before disclosing the identity of any person who has been diagnosed with COVID, the employers should consider whether or not a more generic communication is sufficient to achieve the desired result. Next slide. Okay. In conducting screening, employers need to consider exactly what type of information they need to discharge their statutory duties and then limit their collection to that information only. An employer should also query what is the most minimally invasive way to achieve the balance of discharging their duties under occupational health and safety legislation while also protecting the privacy of employees. As a best practice, and to avoid potential privacy violations at common law, information obtained from screening, as I had mentioned earlier with respect to temperature screening, should not be recorded, stored, or used for any purpose other than determining whether or not the employee should be permitted to enter the workplace. Next slide, please. Next slide, thanks. Okay, so turning to some premises issues, the CECERA is offered through the Canada Mortgage Housing Corporation, and it's intended to lower rent by 75% for impacted small businesses and charities that rent property from qualifying landlords. Rent is lowered through an agreement whereby the landlord will reduce the rent by 25%, the tenant will pay 25%, and then the government will pay the remainder through the program. This program does not apply to any federal, provincial, or municipal owned properties or where the government is a landlord, except where the property owner is a post-secondary institution, a hospital, or a pension fund. The application for this opened on May 25th, and at this time, they'll accept applications until August 31st. I'm going to skip to the next slide. So of note is that earlier this week, the Government of Ontario passed Protecting Small Businesses Act, which temporarily halts and reverses evictions for commercial tenants. The legislation extends to those businesses that are eligible for provincial or federal rent assistance and applies in respect of evictions from May 1st to August 31st. This doesn't apply to, however, to commercial tenants who are participating in the CECERA, because that program already requires landlords to commit to a moratorium on evictions for 6 months. This legislation will be helpful for tenants whose landlords are not participating in the CECERA, and therefore the tenants are not privy to the eviction protections offered to participants thereof. However, we hope that you don't get to a point where eviction is an issue, so communication with your landlord is key. A large number of businesses are seeking rent relief from landlords, so if this is something that your organization wishes to do, you should do it sooner rather than later. As part of your discussion with your landlord, you should discuss various options that might be available to assist during this time, including a temporary suspension, such as a rent holiday or a deferral of payments. But please, if negotiations lead to a rent relief arrangement, it's important to get the arrangement in writing and to have it reviewed by your legal counsel. And finally, as part of this process, you should review your lease, and as Terry said, read your contracts to see what your rights are and how they might be affected by the current pandemic. Following SARS, many commercial leases are drafted to include emergency provisions which give landlords special rights in the event of a health emergency, such as the ability to further control access to the premises or to reduce services that are offered during this time, such as cleaning services. I don't see any questions.
Okay, well, Laurie, thank you very much. That was a lot to get through. I really appreciate that practical advice. We are certainly getting a lot of questions about employee testing, and so that information you provided was really very helpful. Thank you. So just, I'm going to make a couple of housekeeping wrap-up notes, and then I think Terry will say a few things, and we'll let you get back to your regular workday. So first of all, I want to remind you, please, to complete the survey. You'll see a button for it at the bottom of your screen. Again, we really appreciate the feedback we get on these seminars. They help us know what we should be offering you in the future that will be of assistance to you. I told you at the beginning about the materials tab, and that tab includes not only this PowerPoint presentation, but some descriptions about our respective practices, our charities practices, and some bulletins and handouts that we think will be relevant to you right now. And finally, I do want to encourage you to visit the Carter's website and the Fasken's website for continually updated bulletins, blog posts, and upcoming webinar information. Thank you so much for your time. I'm going to turn it over to Terry to give us some final parting words.
Well, thank you, Lynn, and thank you for moderating the seminar, the webinar today. The only comment I want to give is you've got a ton of information, and it's okay to feel overwhelmed. It's just take a deep breath, and we're all in it together. We all have to sort through the issues. Long as you're trying to be up to date, trying to make reasonable decisions, you're going to be headed in the right direction. So we wanted this to equip you with some resource tools to help you with the work, the essential work that you're doing. We are so fortunate in Ontario and Canada to have healthcare charities that have given so much to the community. So on behalf of both our firm as well as Fasken's, we want to thank you for all that you do in making Canada such a fantastic place to be. We are very fortunate. Thank you so much, and we look forward to seeing you next year at the 18th annual Healthcare Philanthropy Seminar, webinar. Who knows what it's going to be, but we're looking forward to it, and thank you for participating today.